morning, everyone. Very glad and honored to be with you. Hopefully, we'll have interesting 2 days. So, just a brief on myself. I'm Moutaz Abdullat, the General Legal Counsel, working with Ferrero Gulf countries, responsible for the region of GCC, the Gulf Cooperation Council. Before working with Ferrero, I used to work with Nestle for 5 years, and prior that, I used to work as a lawyer in private practice. So, once I started my career as a lawyer, actually, it was in Jordan, then I shifted here in Dubai. So at that time when I reached in 2007 and 2008, actually it was the crisis. So you can imagine the load of work we had at that time. As a lawyer, it was a good opportunity for us. One of that thing that, just to break the ice and open the subject, there was like one of the conflicts that I can remember right now, that two parties had a standard contract by which they agreed on the arbitration. And they chose XYZ, for instance, center to arbitrate. So when the conflict arose and the dispute arose, they want to approach the arbitration center they agreed on based on the contract. So when they went there, the arbitration center replied, okay, but we are not aware about this. You didn't record the contract with us, so we need to apologize. We can't look into this conflict because we don't have the ability to do so. Maybe it's something weird for the European colleagues, maybe it's not, but at the end of the day, this is a true story and it happened. So what I'm trying to say here that it's worth to check and do our homework as lawyers since the first beginning and see what is the decision on the ADR, what's our choice, what is the best for us. How we will do that? Maybe somebody will like the arbitration, mediation, negotiation, whatsoever, or they love the court. The idea is there's no single method in my right. In my opinion, there's no single one that will work. We need to do our homework. How we will do our homework? The first thing you need to know is your company. First of all, you need to know your company, your client, what kind of services they are doing, what's the objective size, kind of the litigation history, for instance. So, LLC, limited liability company, can be different than a branch of a foreign company. So the branch of a foreign company, in terms of the liability, it will goes and total to the mother company. So the mother company will be responsible as this. I recall one of the companies here, they have, because the laws in the GCC, actually you need to have like a 51% of a local partner. So you can't have like 100% ownership. Some of them will be a silent partner, not active, just for the sake of formality. Some of them would be like an active partner. So the idea, you need to know exactly what's your objectives, what kind of operations you are doing, and what kind of proposed dispute you might raise in order to find. You will go, for instance, with the commercial agency. Here as well, there's a differentiation between distribution agreement, regular one, and the commercial agency one, because if you want to appoint an agent, it would be very difficult to revoke this because the agent himself, he needs to approach the ministry and deregister from there to be like an agent. So this is important as well in drafting the contracts from the first beginning to differentiate. Is it distribution agreement? It's a commercial agency agreement. Again, if you will approach a court in such a case, by default, the law is in favor of the local partner. So at the end of the day, they will be somehow in their part. So maybe it's good to choose something like arbitration in Europe if you have a European company, or so, in case, of course, they will approve everything based on the negotiation. For instance, in the construction field or insurance company, if you will think about it, most of them will have like a standard clause for the arbitration. So they don't want to be like hassled all the time in the courts because of the load of the how much cases they have. So after knowing your company, the objectives, all of that, you need to know as well your opponent. For instance, in the FMCG, if I would say on my company, in our case, who's our biggest clients? Our biggest clients are the modern trade. We call it the modern trade, which is the Coop. For instance, Carrefour, Spinneys, all of that. So those kind of companies, if you will go there, you will see that they have something called private label. What is the private label? It's their product, okay? So their eyes, it would be like a name as a Carrefour, whatsoever. So these kind of private label, most of the time, would be inspired from the well-known player in that category, okay? So this would be, from a business legal point of view, a challenging position, because I can't recall single case by which it was handled by legal. All of the time it has been business to business. Because if you will interfere in legal case, then you will lose one of your biggest clients. So just to know your opponents. This would be completely different if you're dealing, for instance, procurement contract, dealing with only one-time contract. So if it's one-time contract, there's no need to go to negotiation or mediation. You can directly, for instance, put it with Dubai courts, which is, by the way, one of the biggest and effective courts in the region. Knowing as well the contract of the nature. You need to know the contract of the nature. What is it? If it's, for instance, something related to trademark, patent, trade secret issue, this is most of the time it will be linked, for instance, if the creative team within the company came up with the slogan that they want to register, for instance, or something kind of invention, this will be linked to the marketing campaign that you need to launch. So they will have a tight deadline to work on. So it would be wise to choose something very fast. If you will go, for instance, with the litigation, it will probably will go for 2 to 3 years. Then, of course, it will delay the launch of your product and it will delay as well the launch of the invention itself. So this is to know the nature of the contract. Of course, it depends on the contract. Knowing the jurisdiction applicable and enforceability. For instance, it's not wise to choose arbitration in Saudi because up to the moment, there's no, it's not tested yet. So if you will have like an arbitration award, how you will enforce it, for instance, in countries rather than Saudi or any other GCC. So this is the thing. You need to know exactly if it's tested before, it was dealt before or something like that. This is the kind of homework either the in-house lawyer or the lawyer himself will do prior doing the contract or starting with the bids. Now shifting to the elements to be considered. After doing our homework, we need to think about things. So the first one is willingness and the commitment to go with the ADR. So are we willing to go with it, or it's just for the sake of drafting and finalizing the contract? This is the mentality that the business and the in-house lawyers in both parties need to consider and act upon it. So it's not just a clause that we will need to draft. And the example that I provided in the beginning is an example of it. So if we will choose the arbitration, let's check if this center will be applicable for us. The conflict in place, it's about the relationship. So again, I would say it's about the both parties. Is it one-time relationship? It's a long-time relationship. Is it a business-to-business approach? If this with the negotiation would be the best, or the mediation, because at the end of the day, there's nothing to lose. There's no commitment at the end. The urgency of the matter, again, we will go back to the trademark, patent, invention things. Cost and privacy, of course. So these things as well you need to consider. These factors, elements need to consider prior taking the decision or the choice on the ADR. Involvement of the owners or the management. Again, if you will go with the ADR, actually it would be a very good decision in terms of you want to put all the management, the ownership along with the legal. Because when you say something about litigation or ADR, it goes directly to our mind that it's a legal issue. In fact, it's not. If you will go with the ADR, it will involve a lot of management. It will a lot of business people. So this is kind of the balance you need to think about it. Do we need to bring them on the table, or is it wise to keep them aside? No need. Let's stick it to legal, pure legal. So this is the idea that you need to think about it. And another highlight things, who should take the decision? Who should take the call on the ADR? Is it the in-house lawyers? Is it the outsource lawyer? It's the private practice, the lawyers you are dealing with, or is it the management? Who should take care of this? I'll give you an example. Before 2 weeks, our company actually launched a campaign in Dubai Mall. Dubai Mall is owned by A'mar, one of the biggest developer over the world, by which we make like a big tree. It's over the news, you can Google it. So the idea is, first, we as a company, we are dealing through distributor. So we're not allowed to do trade, okay? So we have our distributor. So the product is coming from Luxembourg, all right, from the factory. Once it's coming here, you have a clearance agency. So we're talking about one party, okay? Forget about the factory, one part. There's the clearance agency who will clear and put it in the warehouse of the distributor, by the way that we should deal with him for the sake of taking the shipment from here to the warehouse of Dubai Mall. But there's no invoice in this case because they are not involved in such a kind. But in their books, they need to have like such kind of invoice. Then in Dubai Mall, in I'mar, they kind of specific list that they can rent inside the mall. So we are not allowed to go directly and rent a space. So you need some kind of agency who's listed there to do the work for you. So we find an agency to do the renting for us, and this is the role of the agency. And at the end of the day, we find a place inside the Dubai Mall who's allowed to do the trading, the selling and buying, okay, to give us the manpower to do the selling. So imagine how many contracts we have in this simple daily case. And by the way, not all of them will be able or open to negotiation, because at the end of the day, when you're dealing with the I'mar, they have their standard format. When you're dealing with the government, they have their standard format. And some of them, they're not dealing with any kind of contract. And you will put an insurance whatsoever. So in this, if this is the case, who's taking the decision on what kind of proposed dispute to deal with? Is it the in-house, or the lawyer, or in my opinion, it's all of us. Again, the business is important. The in-house is business-oriented as well. And of course, the private practice is the expert in the field and on the ground. So all of them need to sit together to understand the situation and to act fast on all of this. So this is like just very high-level notes. Keeping the floor to my colleagues who's the expert in this field to provide more detailed and deep analysis on this. So hopefully I managed to finish super quick. No, that's right. Thank you so much. Thank you.